Mr. Delali Brempong, but also Honorable St. George, Dr. Dominic Ayine applied to this commission to recall a witness of witnesses who have previously appeared and testified before us with a view to further cross-examining them on their previous testimony. We hereby rule on the said application. Council based the application on section 11(1)(c) and 12(2) of the Commission of Inquiry, Practice and Procedure Rules, 2010. Let me read the first provision on which your application was based. 12(1)(c) states that the lawyer for the Commission is responsible for, I'm going to omit reading A and B, now go straight to C. The lawyer for the Commission is responsible for the re-examination of the witness after the cross-examination of the witness by any other lawyer appearing before the Commission. So that section refers to re-examination by the lawyer for the Commission and not by counsel for any witness appearing before the Commission. The second section on which you based your application was section 12(2), and I'll read that section. A lawyer or an expert witness appearing for a person whose conduct is the subject of the inquiry, and any other lawyer appearing before the Commission may cross-examine a witness after the examination of the witness by the lawyer of the Commission, by the lawyer for the Commission, having regard to Article 283 of the Constitution. Now, neither Mr. Delali nor Honorable St. George is a person whose conduct is the subject of the inquiry, of this particular inquiry. Looking at our terms of reference, neither of these two witnesses is the subject of our inquiry. Now let me just read and give some explanation which will assist in understanding also the procedure or the process that we are undertaking. The Commission seeks to give all witnesses appearing before it the opportunity to testify and supply the Commission with as much information as will be possible for the full and complete performance of its work. In this regard, all witnesses are allowed the opportunity to make statements, tender evidence, respond to questions, and advise the Commission on all matters connected to the investigation. It is therefore open to a witness to advise the Commission of the relevance of particular evidence and the necessity, therefore, of calling a witness in that regard to testify on issues alluded to in a witness's evidence. When so done, a witness may be deemed to be aiding the Commission in its work to ensure that all matters of relevance are considered and incorporated in its ultimate findings and recommendations. However, it is important to bear in mind the fact that this is an investigative body whose core task is to conduct a thorough, dispassionate, and accurate inquiry into the matters falling under its remit pursuant to CI 111. In other words, the work of the Commission, unlike that of a regular court, is not to decide what the balance of rights and liabilities are between competing parties, and the rules of evidence do not apply in the same way and sense. Consequently, the evidentiary methodology of the Commission differs from that of a court in the sense that whereas the evidence led by parties in a court are, quote, party-led or centered, unquote, in nature, the evidence given and led before the Commission is Commission-led or centered, in quotes, given that parties do not appear before the Commission to testify in pursuit of their own interest or the advancement of a selfish cause, but rather that that witnesses who appear to testify before the Commission do so to aid the Commission arrive at the truth in respect of the facts implicated in its mandate. In this regard, the request by a party to call a witness with a view to impeaching the prior testimony of the party may have the effect of converting the nature and ethos of the Commission's work and transform its public enterprise character into proceedings in defense of private rights. This may further undermine the freedom to testify afforded all witnesses appearing before the Commission, as parties will now have worry about confronting persons who are aggrieved by their testimony. In light of the above reasons, the Commission declined the request by counsel for both Mr. Deleli Brencon as well as Honorable St. George to recall a witness or witnesses with a view to cross-examining them. In arriving at this conclusion, we are also guided by the dangerous precedent that may be set by according to this request, by which all witnesses may now choose to exercise the option of recalling witnesses with a view to cross-examining them. This will fundamentally disrupt the proceedings of the Commission and undermine the structure and orientation of the proceedings. If granted, judicial equity will demand that similarly situated applicants and applications should also be granted, and that cannot be countenanced for the reasons given above. The Commission has for good reason adopted an inquisitorial approach in its examination of witnesses, and this should take care of the concerns of witnesses like the applicants in this case. On the other hand, if the applicants are so minded, the Commission would advise that they can submit specific questions or queries or concerns and may forward submissions in law or fact to the Secretariat of the Commission for the consideration of the Commission. The Commission seizes the opportunity to again thank the applicants and counsel for their cooperation and evidence submitted before the Commission.